Welcome to Castrip, where real courtroom drama meets shocking twists. From explosive testimonies to judges dropping bombshells, we break it all down. Subscribe at OIT.
I just want to say that I do apologize to the court, and I apologize to mom. And I need some things like no joke, but I just want to get a chance to get home and take care of my kids. I miss graduation, I miss prom, my whole senior year. I got a 5-year-old in kindergarten, and my mom got to take care of. I'm just tired, and I want the opportunity to get my life together. I'm tired of this. I'm tired of this. I'm old. I miss my daughter's graduation. She spoke at West graduation. I was not there. I'm tired. My baby asking me why I'm the only mom. I'm not at mom's and muffins. This is embarrassing for my kids. I want to go for my kids. That's what a chance to do right. Mama, thank you.
That was not just an apology. That was a plea soaked in pain, motherhood, and pure exhaustion. Can you imagine missing your child's graduation just because you are behind bars? Drop a comment. Do you think emotional appeals like this sway the judge? Or is it too little, too late?
Ms. Rideau was previously in court, entered pleas of guilty in cause numbers 23-0928, 23-2106, 23-2107, and 24-1925. All of those were theft of property with previous convictions. I have received...
Okay, pause. The charges: theft of property with previous convictions and multiple case numbers. That tells us this is not her first dance in front of a judge. In legal terms, that prior record is a massive weight on the sentencing scale. Judges don't ignore repeat offenses, no matter how heartfelt the apology sounds.
The pre-sentence report. Has everyone had an opportunity to review that report?
I think so. The state has, Judge.
And there was no agreement. This was just open to the court. Is that correct?
Yes, Your Honor. I believe so, Your Honor. I didn't represent her at the stage where she entered the plea.
Okay.
My understanding is that
they were open. And are there any additions or corrections to the pre-sentence report?
None from different.
Not from the state, Judge.
In addition to reviewing that, the state has filed a couple of things. One is a motion for me to run any sentences consecutively, which means obviously stacked on top of each other. And I think I could do that in, 2106 and 2107, maybe not, but the other ones I can. Is that? Are they different dates?
I think they're all different.
Are they?
They're
Hold on, I'm looking. Yeah, they're different dates.
Let me make sure. I think all 4 of them.
They are. All right, so asking me to stack any sentences, and then he has filed a sentencing memorandum as well, in addition to a motion for me to deny discretionary jail credit.
Now, this part right here, motion to deny jail credit. That's cold. Normally, if you have already sat in jail pretrial, that time counts toward your sentence. Denying that is like saying, nope, we are adding more time just because. Brutal, but not unheard of, especially when prosecutors want to send a message.
Mr. Kimler, if you would like, you may proceed.
Yeah, I would just note that seems to be an aberrant practice as far as its harshness that the state is attempting to exert on this defendant. And I don't know that it stands out from the few other cases before this court to deserve such treatment, but it is what it is. I would just observe, first of all, regarding the state's posture on consecutive sentences, the denial of discretionary jail credit. The defense certainly has criminal history, but it's not to such an extent or degree in the circumstances the individual cases aren't such an extreme degree that it warrants accumulation. And certainly the denial of her jail credit is something that is problematic. I don't know exactly which jail credit the state is attempting to deny her, but obviously if she's been in pretrial detention on these cases, it seemed that she would be entitled to that jail credit without much controversy. The grounds the state would be attempting to deny that, I don't know, but of course we would argue that she should be received credit as every other defendant before this court has for the jail time credit that they've done pursuant to these cases. I would note that the pre-sentence report indicates that she does have mental health history dating back to her time in the military, where she was discharged. She had a general discharge, and there was notations there as far as the pre-sentence report that would involve some health issues. I believe I believe her to be mentally competent. Now, I of course wasn't her attorney when she entered the plea, but I would assume that she was mentally competent then as well. Although, as I said, she does have mental health history. I think that plays into her present situation with the theft cases that she has. You even note in the pre-sentence report where it's indicated that she was unable to afford the mental health treatment and the pharmacological remedies that are provided through prescriptions, and that she was self-medicating. And
This changes everything. She was not just stealing for fun, she was self-medicating for untreated mental health issues. That turns this from serial theft into survival mode. Mental health and criminal law is a complex mix, and judges walk a tightrope between accountability and compassion.
turn to theft in an attempt to maintain funds necessary to self-medicate. She indicates in the report that her memory indeed was impaired on 3 of these offenses, and she doesn't seem to remember those. She doesn't attempt to minimize or mitigate her conduct in that regard, where she does in fact indicate that she accepts responsibility fully for her actions. But I think that that's indicative of, again, the circumstances surrounding these offenses that, of course, I guess it seems everyone in front of the court these days is finding mental health issues as something that mitigates their criminal conduct. But I do think that in this case it is well documented, going back again to her military history, that she has suffered from mental health issues. I think probation is an option with the court. Obviously, these are state jails. The court can put her on probation. And I know that the pre-sentence report, you can look at that, just to indicate, doesn't really indicate.
So just when probation gets mentioned, boom, judge shuts it down like a locked vault. Not realistic. Today, she says, that line, it's the gavel drop before the actual sentence. No second chances, just consequences.
That they're, while they're not recommending probation for Ms. Rio, they don't rule it out.
Well, let's not talk about probation.
Okay.
Yeah.
All right. I'm sorry, but there is a paragraph for
Well, it is an option, but that's not realistic on what's going to happen today.
they were mentioning that she was assessed with a specialized mental health caseload.
I understand that.
So just to note that.